Hello, I'm attorney Vince Davis. For over 38 years, I've fought to protect the rights of individuals facing the complexities of California's criminal justice system. Our mission is simple: to provide a robust defense against government overreach and ensure that your voice is heard in the courtroom. California's criminal system is primarily governed by the Penal Code, along with the Health, Safety, and Vehicle Codes. In this system, the prosecution carries the heavy burden of proving guilt beyond a reasonable doubt. My job is to challenge that evidence every step of the way. The journey begins with an arrest. Law enforcement typically has 48 hours to bring you before a judge for an arraignment. Those first hours are critical. Immediate legal intervention can often make the difference in how your case is filed. At the arraignment, you'll hear the formal charges and enter a plea. We almost always start with not guilty to allow time for discovery. This is where the formal legal process truly begins, and where having an experienced trial lawyer by your side is essential. Following recent California Supreme Court rulings, judges must now consider your ability to pay when setting bail. We fight for own recognizance release or non-monetary conditions to get you home to your family as soon as possible. Next is the discovery phase. Under the law, the prosecution must hand over all evidence, from police reports to body camera footage. We meticulously review every detail, looking for inconsistencies, constitutional violations, or missing pieces of the puzzle. In felony cases, a preliminary hearing is held. A judge determines if there is enough probable cause to move forward to trial. This is often our first chance to cross-examine the state's witnesses and reveal weaknesses in their case. We also file pretrial motions, such as a motion to suppress evidence that was obtained through an illegal search or seizure. Your constitutional rights are the bedrock of our defense. If the police broke the rules, the evidence shouldn't be used against you. Our firm handles serious violent crime charges, including assault, battery, and complex gang-related allegations. These cases require an aggressive defense and a deep understanding of how to present your side of the story to a jury. We also represent clients in high-stakes white-collar litigation, such as mail fraud, wire fraud, and embezzlement. These cases are often document-heavy and require a masterful approach to complex financial evidence. For minors, the juvenile justice system focuses more on rehabilitation than punishment. We work to protect your child's future. A juvenile mistake shouldn't define a young person's entire life. We fight for outcomes that prioritize growth and second chances. To convict, the state must prove two elements: a criminal act, actus reus, and criminal intent, mens rea. If there was no intent, or if the act didn't occur as described, the prosecution's case falls apart. We challenge their narrative. Self-defense is a common strategy in assault cases. If you had a reasonable belief of imminent danger, you had the right to protect yourself. We work to prove that your actions were necessary and proportional under the circumstances you faced. In California, many crimes are wobblers, meaning they can be charged as either a felony or a misdemeanor. Effective advocacy can lead to a motion to reduce a felony to a misdemeanor, significantly mitigating your exposure. Starting in late 2024, Proposition 36 increased penalties for repeat theft and drug crimes. A third theft can now be a felony. This marks a major shift in how California handles low-level offenses, making expert legal representation more important than ever. In 2026, AB 256 allows anyone with a felony to challenge their conviction if racial bias played a role in their case. This is a powerful new tool to ensure that fairness and equality are upheld in every corner of our legal system. New 2025 laws implement a Watson advisement for fentanyl offenses, warning of future murder charges if a death occurs. The stakes have never been higher for drug-related allegations. You need a defense that understands these new and evolving rules. AB 600 also allows judges to recall and modify sentences to align with modern standards without needing the DA's consent. This provides a pathway for those serving outdated or overly harsh sentences to find justice under current laws. Additionally, AB 321 empowers judges to reclassify wobbler crimes as misdemeanors at any time before trial. This flexibility gives defense attorneys more opportunities to protect their clients' futures from the weight of a felony record. My philosophy is built on aggressive and masterful courtroom presence. I represent the voiceless against government oppression. I've spent my career honing the skills necessary to win difficult cases and ensure that every client gets the defense they deserve. We emphasize high-touch communication. I make myself personally available to help you navigate this scary and confusing process. Whether it's a text or a phone call, we're here to answer your questions and provide the clarity you need. With offices across Southern California, from Arcadia to San Diego, we are ready to assist you wherever you are. Our widespread presence allows us to bring our expertise to local courts throughout the region. I believe that every client has a potentially bright future that deserves to be protected with every legal tool available. Our goal is to find the best possible outcome for you, allowing you to move forward with your life. Don't face these charges alone. The sooner we begin building your defense, the stronger it will be. Experience, skill, and a commitment to justice are what we bring to every case we handle. Call us today at 888-888-6582. Let's discuss your case and start building your defense. Thank you for watching. We look forward to helping you protect your rights and your future.